Imagine this. Your employer filed your PERM labor certification over a year ago. You have been patient. You have been watching the Department of Labor's website every month, and then one day you get a letter. Not an approval, an audit notice, and just like that, your entire green card timeline, the one you and your family have been building your life around, gets pushed back anywhere from 6 months to over a year. And here is the part that should concern every H-1B worker watching this right now. That scenario is not rare anymore. In 2026, the Department of Labor has made it crystal clear that PERM labor certification cases are under a level of scrutiny this program has not seen in years. And if your employer has a PERM case pending or is about to file one, and you are not aware of exactly what triggers an audit, what happens during one, and what the stakes are for your H-1B status, then you are carrying a risk you do not even know you have. That ends right now. Stay with me. Welcome to Immigration Path USA, the channel dedicated to giving you clear, accurate, and timely immigration information without the noise and without the panic. Before we go any further, I need to share an important disclaimer. I am not an attorney. Nothing in this video is legal advice. This content is strictly for educational and informational purposes. Every immigration case is different, complex, and deeply personal. Please always consult with a licensed immigration attorney or accredited representative for advice specific to your situation. Now, let's get into what is really happening at the Department of Labor in 2026 and what it means for you. Let's start with the basics, because if you do not fully understand what PERM is and why it exists, everything else in this video will not land the way it needs to. PERM stands for Program Electronic Review Management. It is the system through which the Department of Labor, not USCIS, but the DOL, certifies that an employer was unable to find a qualified, willing, available U.S. worker to fill a specific position before turning to a foreign national. This certification, filed on Form ETA 9089, is the mandatory first step in the employment-based green card process for the vast majority of EB2 and EB3 applicants. Without a certified PERM, your employer cannot file the I-140 immigrant petition. And without the I-140, you cannot establish your priority date. And without the priority date, your green card clock does not even start running. The PERM process is built around a labor market test. The employer must conduct a genuine, documented recruitment effort, running newspaper ads, posting the position through specific channels, documenting every applicant, evaluating every resume, and justifying every rejection of a U.S. worker who applied. Only after demonstrating that no qualified U.S. worker is available can the employer certify that and file ETA 9089 with the DOL. It sounds straightforward, and in theory, it is. But in practice, it is one of the most technically precise, documentation-heavy processes in all of U.S. immigration law. And in 2026, the DOL's Office of Foreign Labor Certification, the OFLC, is checking the work. Here is what the current landscape actually looks like. As of February 9th, 2026, the DOL is conducting standard analyst review for PERM applications filed in September 2024 or earlier. That means if your employer filed a PERM application in October 2024 or later, it has not even reached the front of the standard review queue yet. For cases not selected for audit, immigration law firms are reporting approval timelines of approximately 16.5 to 17 months from filing date. 17 months for a single form, before the I-140 is even filed. But here is where the numbers get significantly more serious. For cases selected for audit, the DOL is currently reviewing applications filed in June 2025 or earlier. And that audit review is adding months to an already stretched timeline, with some cases waiting over 200 days in the audit queue alone on top of their standard processing time. But here's the catch that most people are missing. The audit is not the only threat. The DOL has set an internal target of conducting integrity checks, audits, and supervised recruitment proceedings on 30% of all PERM cases submitted. 30%. That is nearly 1 in 3 applications coming under enhanced scrutiny. And the consequences of landing in that 30% are severe. Cases placed in audit processing face not just additional delays, but significantly higher denial rates. Cases selected for supervised recruitment, which is an even more intensive form of DOL oversight, where the agency essentially directs the employer's entire recruitment process, face denial rates as high as 67%. Read that again. More than 2 out of 3 supervised recruitment cases end in denial. This is not a theoretical risk. This is the reality of PERM in 2026. So the critical question is, what puts a case in that 30%? What actually triggers an audit? Because if you know the triggers, you can work with your employer and your attorney to either eliminate them or prepare for them proactively. The DOL has been transparent about many of these triggers, and the list matters enormously for anyone in or approaching this process. The first major trigger is a job requirements mismatch. This is the single most common audit trigger in the entire PERM program. If the job description requires a bachelor's degree but includes no prior work experience requirement, the DOL views this as potentially tailored to the foreign worker rather than reflecting a genuine market need. Similarly, if a high-level, high-salary professional position lists unusually low educational or experience thresholds, that signals to the DOL that the requirements may have been set to ensure the foreign worker would qualify while making it easy to reject U.S. applicants. Any requirement that seems artificially constructed or that deviates from what the DOL considers standard for the occupation is a red flag. The second major trigger is industry-specific scrutiny. Certain industries have been placed under heightened DOL scrutiny based on historical patterns of non-compliance. High-tech and computer industry positions are currently among the most watched. Construction-related positions, automotive industry roles, financial and banking sector jobs. If your employer's PERM falls into any of these categories, the statistical probability of audit is meaningfully higher than average. This does not mean the case cannot succeed. It means the documentation must be airtight from day one. The third trigger is a familial or ownership relationship. If the foreign worker being sponsored is related to the owner, officers, or directors of the sponsoring company, or if the foreign worker holds any ownership interest in the company, the DOL treats this as a significant red flag for potential fraud. The concern is straightforward. An employer-employee relationship that is not genuinely arm's length creates an incentive to manipulate the labor market test. These cases receive automatic enhanced scrutiny, and any gap in the recruitment documentation will be found. The fourth trigger is foreign language requirements. If the job posting includes a requirement that applicants speak a language other than English, and that requirement cannot be clearly justified by a genuine business necessity, for example, the position requires communicating with a client base that exclusively speaks that language, the DOL will want an explanation. Foreign language requirements that appear designed to narrow the applicant pool to speakers of a specific language that happens to match the foreign worker's background are a classic audit trigger. The fifth trigger is insufficient or inconsistent recruitment documentation. This is where cases that survive every other check often fall apart. The employer must maintain complete records of every step of the recruitment process, copies of newspaper ads showing the actual dates of publication, complete tier sheets, not just the advertisement text, a log of every applicant who responded, their qualifications, and the specific reason they were not selected. Evidence that the evaluation criteria were established before reviewing applications, not after. If any of these elements are missing, incomplete, or inconsistent with what was reported on the ETA 9089, the DOL will find it during an audit, and then the case will almost certainly be denied. This is where it gets critical for anyone on an H-1B visa who is nearing the 6-year maximum limit, and I want every H-1B worker watching this to pay very close attention to the next 2 minutes. The H-1B visa has a standard 6-year maximum period of authorized stay. After 6 years, the visa cannot simply be renewed under normal circumstances. To get beyond the 6-year cap, the law provides 2 primary pathways under the American Competitiveness in the 21st Century Act, commonly known as AC-21. The first pathway allows for a 1-year H-1B extension if a PERM application or I-140 petition has been filed and has been pending for more than 365 days. The second pathway allows for 3-year H-1B extensions if an I-140 petition has already been approved and the foreign worker cannot file the I-485 adjustment of status application because their visa priority date is not yet current on the visa bulletin. Here is why the PERM audit timeline creates a direct, concrete threat to H-1B workers in this situation. If your PERM case is selected for audit and that audit adds 6 to 12 months to your processing time. And if you are approaching the end of your H-1B 6-year limit during that window, your ability to get the 1-year extension depends entirely on the PERM case having been pending for at least 365 days. If the audit extended timeline delays your case past critical filing or renewal windows without those 365 days of documented pending status, you may find yourself in a precarious position regarding your continued lawful presence in the United States. And if the PERM is ultimately denied after an audit, you are potentially starting the entire process from the beginning, with less time on your H-1B clock than when you started. There's a lifeline in this scenario, and I want to make sure you know it exists. Even if your PERM case is stuck in audit and your I-140 has not yet been filed, if that PERM application has been pending for more than 365 days, including the time spent in audit review, you are potentially eligible for the 1-year H-1B extension. The critical piece is that the PERM must still be active and not denied. This is one of the many reasons why understanding your exact filing date, your exact H-1B expiration timeline, and your audit status is not something you can track casually. It requires active, precise case management. Let me tell you about a situation I want to call the Patel family's case, and I'm using that name to protect privacy. Ravi Patel had been in the United States on an H-1B visa for nearly 5.5 years, working as a senior software architect for a mid-sized technology firm in Texas. His employer initiated the PERM process about 2 years before his 6-year H-1B limit was set to expire, which on paper seemed like plenty of time. The PERM was filed on ETA 9089 in early 2024. The job description required a master's degree in computer science. No prior work experience was required because the employer genuinely believed the master's degree was sufficient for the role. What the employer did not know, and what their HR team had not flagged to their immigration attorney, was that this exact combination had become one of the DOL's most watched audit triggers. The case was selected for audit 7 months after filing. The DOL requested comprehensive documentation of the entire recruitment process, detailed justification for why no prior experience was required for a senior-level position, and evidence of the employer's ability to pay the offered wage. The audit response took 2 months to prepare. Then the case sat in the audit review queue. Ravi's H-1B was approaching expiration. The 1-year extension was filed based on the PERM having been pending for over 365 days, and it was approved, which gave the family critical relief. But the audit itself was not resolved for another 9 months after the response was submitted. What should have been a clean 14-month PERM process turned into a 28-month ordeal that put Ravi's status, his wife's H-4 work authorization, and their family's stability under enormous stress for over 2 years. The case was ultimately approved, but the cost, in legal fees, in anxiety, and in time, was a price no one had planned for. Now let's talk about what you and your employer can actually do. Here is your 3-step action plan for navigating PERM audits in 2026. Step 1. Conduct an honest audit risk assessment before you file. Before ETA 9089 is submitted to the DOL, every element of the job description needs to be reviewed against the known audit triggers. Does the education requirement match the experience requirement in a way that reflects genuine industry standards? Can every element of the job requirements be justified by actual business necessity, documented clearly? Is there any familial relationship between the foreign worker and company ownership that needs to be disclosed and addressed? Is the position in one of the DOL's high scrutiny industries? Does the job posting include any language requirement that needs a business necessity justification? If the answer to any of these questions is yes, the case is not unfixable, but it needs to be built with the audit response already in mind. That means the justification documentation goes into the file before the audit request ever arrives. Work with an experienced immigration attorney to stress test the job description and the recruitment plan before a single ad is placed. Step 2, build an audit-ready recruitment file from day 1. The DOL's audit request is not a surprise in terms of what it will ask for. It will ask for the newspaper tier sheets showing the full publication dates. It will ask for the complete applicant log. It will ask for the documented evaluation criteria. It will ask for copies of every rejection notice and the specific reason for each rejection. It will ask for evidence that the employer's evaluation process was applied consistently and fairly to every applicant. All of this documentation should be organized and preserved from the moment the recruitment process begins, not assembled retroactively when the audit letter arrives. Take dated photographs of internal job postings. Save every email communication related to the recruitment. Store everything in a secure, organized, audit-ready file that can be submitted promptly and completely if the DOL requests it. A slow or disorganized audit response only extends your timeline further. Step 3. Know your H-1B clock and your extension eligibility window precisely. If you are currently on an H-1B visa, you need to know your exact 6-year limit date, your exact PERM filing date, and the specific date on which your PERM will have been pending for 365 days. These 3 dates are the foundation of your extension strategy under AC-21. If your PERM is audited and the audit adds months to your timeline, understanding these dates allows your attorney to plan your H-1B extension filing with precision, ensuring your status does not lapse while the DOL completes its review. Additionally, if your PERM is approved and you move to the I-140 stage, evaluate premium processing through Form I-907 seriously. For eligible employment-based categories, the $2,805 premium processing fee compresses the I-140 timeline from months to 15 business days. And once that I-140 is approved, you have established your priority date and potentially unlocked 3-year H-1B extensions that give you far more breathing room. There is one more tool you need to know about, and it connects directly to what happens when a PERM case has been in audit for an unreasonably long time with no action. Earlier in this channel, we discussed the writ of mandamus, a federal court action to compel a government agency to perform a duty it is legally required to perform. The same tool that applies to USCIS cases stuck in extreme delay can, in certain circumstances, be applied to DOL proceedings. If a PERM audit response has been submitted completely and on time, and the DOL has taken no action for an unreasonable period, an immigration attorney may advise exploring whether administrative remedies have been exhausted and whether a federal court action is appropriate. This is a last resort, but it is a real one. And in 2026, it is being used. Here is the broader trajectory you need to understand about where PERM enforcement is heading. The DOL's stated goal of running integrity checks on 30% of cases is not softening. Federal enforcement posture across immigration-related programs has been strengthening, not loosening. The October 2025 government shutdown, which closed the OFLC for nearly a full month, created a backlog that the agency is still working through, and that pressure on the system tends to intensify scrutiny rather than reduce it. The backlog of pending PERM applications sat at over 192,000 cases as of late 2024, and it has continued to grow. With the DOL processing PERM applications filed in September 2024 only as of February 2026, the gap between filing and adjudication is not narrowing on its own. Every month that passes without a strategic, proactive filing posture is a month of additional risk exposure. If there is one thing I want you to take from this video, it is this. The PERM process is not a form you fill out and wait on. It is a legal proceeding with documentation requirements, compliance standards, audit triggers, and timeline consequences that can affect your entire immigration future. The employers and workers who navigate it successfully in 2026 are the ones who treat it that way from day one, not the ones who find out after the audit letter arrives. Talk to your employer about where your PERM filing stands right now. If it has not been started and you are within 2 years of your H-1B 6-year limit, that conversation needs to happen today. If it is already pending, ask your attorney what the audit risk profile looks like for your specific case and what documentation has already been preserved. And if you are in an audit right now, make sure the response is being prepared by someone who knows this process cold. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential.